on our breaking news. A second judge has ruled that the Trump administration must use emergency funds to at least partially cover SNAP benefits in November. Remember, 42 million Americans depend on these benefits for groceries to feed themselves and their families.
Yeah, so many people. And Renee Marsh is following this. Renee, what else are we learning? A very quickly moving story here.
Yeah, so these two judges, one in Boston and one in Rhode Island, making these decisions just minutes apart.
Trump's legal approach has always been the same. Fight every ruling, claim every right, push back on every demand, stretch every time limit, run down the clock, and wear out anyone who comes after him. The aim is always to push real consequences as far away as possible, making it too costly for most people to keep going. That method, built and sharpened over hundreds of legal fights across 4 decades in business and politics, has one clear and known weak spot. One situation that this whole system of delay and dodging is built to avoid: Donald Trump sitting in a witness chair under oath answering direct questions on the record.
We've done so much. Energy is way down. Look at energy. We're going to have $2 gasoline. I did that. That brings everything else down. Groceries are way down other than beef. Now, beef is going to come down. We have to do that. The fact is we have prices way down. We have prices down. Our country's doing well.
So inflation, just as a factual matter, it's at its highest rate since January when President Trump took office. Groceries are up across all product categories, not just beef, according to the Bureau of Labor Statistics. Americans are paying close to $200 more.
No lawyer to speak for him, no press statement in place of a real answer, no legal move to shut the question down, just Trump and the oath and the question, and whatever comes out of his mouth next becoming a permanent part of the sworn legal record of the case. And tonight, a federal judge has ordered exactly that. Not in 6 months, not after the next round of appeals. In 48 to 72 hours, show up, sit down, take the oath, answer the questions, or face contempt. Face the U.S. Marshals. Face a situation that has been the distant possible outcome of every accountability case and is now the actual immediate reality of this one. Trump is stuck because there is no legal move left that gets him out of this specific.
This is quite a ruling from this judge ordering the federal government to make these payments in full when it comes to these SNAP benefits for 42 million Americans who have kind of been left in the middle and the lurch of all of this, as there's been this dispute playing out inside the courtroom from groups that are suing the administration over not paying these benefits during this government shutdown. And something that stood out to me, Jake, is something the judge referenced in this decision today, in this ruling, saying that they must make these SNAP payments by Friday, by tomorrow.
Room on this specific timeline. The New York civil fraud trial gave everyone a look at what Trump under oath actually looks like in real life. It is not the smooth and carefully controlled performance of a man reading from a prepared script at a press event. It is a raw and often contradictory and frequently damaging account of a man who is not used to being in a setting where he cannot control the story, cannot shift the conversation, and cannot simply refuse to answer and walk out. The New York civil fraud testimony was just a preview. The forced federal testimony we are talking about tonight is the main event. Every legal expert who watched what happened in that New York courtroom when Trump sat under oath understands why the idea of broader sworn testimony covering not just the civil fraud, but the obstruction.
The president said on Truth Social earlier this week, after the administration was ordered to pay about half of the SNAP payments, what they had from that contingency fund that they had, that had created a lot of questions here during the White House briefing, Jake, where Caroline Leavitt was acknowledging the president's post, but essentially saying that they were still complying with the court order. Those were actually talking points that were sent up to Republicans on Capitol Hill. The judge took it very differently and saw it as basically a rebuke of his order to pay those
classified documents, election interference, and every other case where his testimony matters legally is the exact situation his legal team has spent years and hundreds of millions in donor money trying to stop. The oath is the weak spot, and tonight a federal judge has ordered him directly into it with a deadline that the delay strategy cannot handle. The 48 to 72 hours is not random. It is the single most important part of the order in terms of shutting down the delay tactics that Trump's legal team has used successfully to stretch out every previous run-in with forced testimony. The normal time needed to fight a testimony order through the appeals process, filing a request to pause, arguing the appeal, waiting for the appeals panel.
The Trump administration's lawyers had argued that they weren't mandated to use this emergency fund, and they said that the shutdown was actually not an emergency situation in which they would move to use these funds. To that, the lawyers representing both the cities and the nonprofits who were challenging the suspension of this program said that millions of people not having access to food indeed is an emergency. So this judge in Rhode Island essentially ordered them to release these funds as soon as possible.
Hearing and getting a ruling takes weeks at the least and often months. Trump's legal team has used that appeals timeline on purpose and repeatedly to push testimony deadlines past the point where they could cause real consequences within the relevant legal or political window. The 48 to 72-hour deadline is specifically built to make that appeals strategy impossible. An emergency request to pause filed in 48 hours with a contempt order and U.S. Marshal arrest as the alternative requires an emergency appeals court response that appeals courts are very reluctant to give without proof of serious harm that clearly outweighs the other side's interest. The judge who issued the order has already ruled on the privilege and immunity claims.
The judge ordering the administration to fully fund SNAP benefits this month, and the Trump administration fighting that.
Well, look, Republicans want to get the SNAP benefits, and we've given the Democrats 13 times to vote to do just that. And even tomorrow, they're telling us they're going to vote against SNAP benefits once again. So I think that the Trump organization, the Trump administration, was going to use these $5 billion of emergency funds that were meant for disasters. The judge told them to use those, so they will.
Those rulings are on record. The appeals court would have to overturn the lower court's already issued rulings on an emergency timeline with no hearing and no full argument, a legal standard that is extremely hard to meet in 48 to 72 hours, even for a well-funded legal team with strong appeals lawyers. Think about what that means for a legal strategy that has always relied on the appeals timeline as the main tool for turning a losing legal position into a long delay. The tight timeline kills the strategy. A strategy that cannot work within the time given is not a strategy. It is a surrender waiting to happen on the worst possible terms. The scope of the testimony matters a great deal. The order covers multiple active investigations at the same time. The fraud and obstruction investigations that are the main stated reason for the order, plus the related money and document handling questions built up across the civil fraud case, the classified documents case, and the broader obstruction investigation. Trump is not being asked to testify about one specific and limited set of facts in one specific and limited legal case. He is being ordered to answer questions that cover the full range of active legal matters against him. Questions about money valuations, about how documents were handled, about conversations with advisors and lawyers and co-defendants, about what he knew and when he knew it, and what he told other people to do based on that knowledge. The full range of active legal matters covered in a single forced testimony session is what makes the order so specifically dangerous for Trump beyond simply being placed under oath. Contradictions across different topics in a single testimony session are easier to prove and easier to charge as lying under oath than contradictions that come up across multiple separate cases over long stretches of time. One single sworn session covering all the active investigations creates one unified record of everything Trump said about all of it at the same moment. That single record is available to prosecutors in every active case at the same time, not as a piece of evidence in one case, but as a shared resource that can be used to test whether everything Trump's team has been arguing across every case holds together. The privilege rulings have already been fought over at length. The judge has already ruled that presidential privilege does not apply to the specific types of communications being asked about, because those types involve personal and political actions rather than the carrying out of core presidential duties. The crime exception to lawyer-client privilege applies because the communications in question were used to carry out alleged crimes rather than for honest legal advice. The legal protection for work materials does not cover things that were created as part of the very conduct being investigated. Those rulings are on the record. They are well-reasoned decisions that address the specific legal arguments Trump's team made. An appeals court looking at those rulings on an emergency pause request in 48 hours would have to find that the lower court made a clear legal mistake in settling those well-argued privilege questions, a standard that is extremely hard to meet when the lower court has produced a detailed written decision on each issue. The privilege doors are shut. The path through the appeals court using privilege arguments is effectively blocked. Without the privilege arguments, without the procedural tools that have been the main weapons of the delay strategy across every previous confrontation, the only options left in response to the order are to comply or face contempt. The lying under oath dimension is where things become truly dangerous for Trump. What happens under oath in the next 48 to 72 hours is not just a legal event contained within this specific case. It is a sworn record that becomes available to prosecutors across every active case running at the same time, and that creates specific criminal risk for every statement Trump makes that can be shown to be false. The lying under oath law is simple and harsh in the context of a witness who has spent years making contradictory statements across multiple legal and political settings. To lie under oath in federal court, a person has to make a false statement under oath about something that matters, a fact that is relevant to the case while knowing that the statement is false. The paper and evidence record that prosecutors have built across the classified documents case, the election interference investigation, the civil fraud case, and the cooperation materials is a complete collection of what Trump and the people around him have said and done and discussed privately about every major factual question that will be covered in the forced testimony. That collection is the lying under oath trap. Not a trap that prosecutors set on purpose, but a trap that the documented record itself creates whenever a witness who has made contradictory statements across multiple settings is placed under oath and required to give one single definitive sworn account of the facts. Every statement Trump makes under oath in that room will be immediately and at the same time checked against the document record across every active case. Every answer that differs from what the internal records show is a potential lying under oath charge. Unlike the political and public settings where Trump has been making contradictory statements for years without any direct legal consequences for those contradictions, the sworn testimony session creates a single document that can be used to prosecute the specific false statements it contains. No matter what Trump argues about context or meaning or interpretation afterward, the next 48 to 72 hours will produce a legal record that will be examined and checked against every active investigation at the same time. The contempt situation is where the judge's clear authorization of U.S. Marshal arrest as the enforcement tool becomes critical. That authorization is not an empty threat. It is a specific and ready directive that the Marshal Service is now positioned to carry out if Trump refuses to follow the testimony order within the given window. The U.S. Marshals are the enforcement arm of the federal courts, officers of the court system whose institutional duty runs to the court rather than to the president. Their authority to carry out a valid court order, including a contempt order that allows arrest to force compliance, does not depend on the agreement or cooperation of the Secret Service. The constitutional authority of the federal courts to enforce their own orders through their own enforcement arm is the foundational institutional power of the court system as an equal and independent branch of government. A sitting president who refuses to follow a valid federal court order forcing his testimony and who is then hit with a contempt order allowing martial arrest is exactly the constitutional situation that the separation of powers was built to handle. The question of whether the Secret Service would stand between the marshals and a president who has been ordered into custody until he follows the testimony order is the constitutional face-off that makes this forced testimony order the most serious and most immediate clash between branches of government in the entire history of Trump's legal troubles. That face-off has a legally clear answer within the constitutional framework. The courts can enforce their orders. The marshals can carry out contempt orders. A president who defies a valid court order is not above the law, regardless of what the Secret Service's protective role requires in other situations. Legal experts calling this make or break are not exaggerating. They are describing the specific legal reality that makes forced spoken testimony under oath completely different from every other type of evidence or case that has been part of this legal story. Written evidence, however complete, requires prosecutors to interpret it and a jury to evaluate it before it produces any consequences. Witness testimony, however helpful, requires credibility checks and cross-examination before it can be used to build the case against the main target. But Trump's own sworn testimony, his own words, his own answers, his own choice of what to say about specific facts when he cannot redirect or delay or hand it off to someone else, is the most direct and most legally raw form of evidence available in any case. If he answers truthfully, he incriminates himself directly in his own words, and those damaging statements are immediately available to prosecutors across every active case. If he refuses to answer on valid legal grounds, he gives prosecutors a record of specific areas where he is claiming protection from self-incrimination, a claim that juries in civil cases can draw negative conclusions from, and that prosecutors can use to identify the specific factual areas where the paper record is most likely to prove criminal conduct. If he answers falsely, if he makes sworn statements that the document record contradicts, he creates lying under oath exposure that stands on its own apart from every other charge in every other case. That is one of the most straightforwardly chargeable federal crimes available because the false statement and the document contradiction are both already on the record before the testimony even ends. There is no version of sitting in that witness chair that does not produce serious legal consequences. That is exactly why Trump's legal team has spent decades and hundreds of millions of dollars keeping him from ever sitting there. The 48 to 72-hour deadline is the single most legally important detail in the entire forced testimony order because it is specifically built to shut down the delay tactics that have defined Trump's legal strategy across decades of court fights. The one procedural tool that has always been available, the appeals timeline that turns a losing legal argument into months of extra delay, is specifically and deliberately shut down by the structure of the order itself. Trump's legal team cannot file an appeal and wait for a ruling on the normal appeals timeline when the contempt order allowing martial arrest kicks in within 48 hours. They can file an emergency pause request, but the standard for getting one granted, clear legal mistake in the already issued rulings, serious harm, and a strong chance of winning on the merits is extremely hard to meet in 48 hours when the lower court has already issued detailed written decisions on each of the legal arguments the pause request would need to raise. The deadline is not just an administrative detail, it is the legal tool that makes this order different in nature from every previous forced testimony demand that the delay strategy successfully handled. A deadline that cannot be outlasted through the normal appeals process is a deadline that produces either compliance or contempt. There is no third option available within this timeline. The specific authorization of U.S. Marshal arrest as the contempt enforcement tool signals that the judge has assessed the chance of non-compliance and has specifically and deliberately structured the order to make non-compliance as costly and as publicly visible as possible. Judges do not include explicit martial arrest authorization in contempt orders for witnesses they expect to comply without resistance. That specific provision is included because the court has looked at the full record of the case to date, the documented history of delay, the documented history of stalling, the documented history of misrepresenting what court orders require, and has concluded that the enforcement tool needs to be clearly stated and clearly authorized before the order is issued rather than after non-compliance creates the need to escalate. The martial arrest authorization is a judicial prediction about likely behavior that is also a judicial statement about the consequences of that behavior and the public visibility of those consequences. The image of U.S. Marshals authorized to take a sitting president into custody until he follows a testimony order is itself a form of judicial pressure that works independently of whether the arrest is ever actually carried out. The political and public cost of being the subject of a martial arrest authorization is significant. Even if compliance ultimately stops the arrest from being carried out, the authorization exists. It is in the order. It is part of the public record. Everyone watching knows that the judge has specifically decided that arrest is the right enforcement tool for this defendant's failure to follow this court's orders. Every possible response Trump can make to the forced testimony order produces serious legal or political consequences that cannot be managed through the normal tools of press statements and social media and political spin. The compliance scenario, Trump shows up, takes the oath, and answers questions, produces sworn testimony that is immediately available to prosecutors across every active case as a reference point for every contradiction with the document record. The self-incrimination refusal scenario, Trump shows up but claims Fifth Amendment protections on specific questions, produces a documented record of specific areas where he is claiming protection from self-incrimination that civil juries can draw negative conclusions from and that prosecutors can use to identify the specific factual areas where the document record is most likely to prove criminal conduct. The non-compliance scenario, Trump refuses to show up and faces contempt, produces the martial arrest confrontation, the most politically and constitutionally dramatic situation in the entire history of his legal troubles. All three scenarios are legally damaging in different ways. None of them can be managed into a neutral outcome through political spin because the record produced by each scenario, the sworn testimony, the Fifth Amendment claims, or the contempt order is a formal legal document that exists permanently and on its own regardless of whatever story Trump's team builds around it afterward. Being in a legal position where every possible response to a single court order produces a different kind of serious consequence with no option available that does not badly damage your legal standing is the definition of a legal trap. Not a trap that prosecutors set, but a trap that the combination of the document record, the privilege rulings, and the tight timeline has created. The forced testimony order matters most because it represents the specific moment when the 4-decade delay strategy that has protected Trump from the one situation most dangerous to his legal survival finally meets a judicial decision that the strategy will not be allowed to work on its normal timeline in this specific case. Every previous accountability moment in Trump's legal story, every hearing, every contempt finding, every asset freeze, every indictment has allowed time between the legal development and the consequence it was meant to produce. Time that the delay strategy has used to shape the political story, to build the appeal, to find the procedural move that stretches the timeline, to wait for the political environment to shift in ways that might reduce the consequence before it fully lands. This order does not allow that time. 48 to 72 hours is not a timeline within which the 4-decade delay strategy can work. It is the one timeline that the delay strategy cannot outlast. A legal strategy that has worked for 4 decades by stretching out every timeline thrown at it is now facing the one timeline that cannot be stretched. The person who built that strategy around never sitting in the witness chair is now sitting 48 to 72 hours away from exactly that chair. Whether his strategy has a response or not, the judge has made the decision. The order is issued. The timeline is running. The one thing Trump has spent more time and money and energy avoiding than anything else in his entire public life is now the thing he is most immediately facing. The comparison to every previous testimony demand is telling. Every previous time Trump has been ordered to testify under oath, there has been time to appeal, time to fight privilege, time to negotiate scope, time to let the news cycle move on, time for something else to become the story. This time, there is no time. The judge has structured the order specifically to remove time as a strategic tool. The appeals path that has always been available is effectively blocked by the tight timeline. The privilege arguments that have always been available have already been ruled on in detailed written decisions. The delay tools that have always been available cannot work within 48 to 72 hours. All that remains is the witness chair. All that remains is the oath. All that remains is the record that will be created in that room on that timeline under those conditions. That is why this moment is different from every previous accountability moment in Trump's legal story. Not because the stakes are higher, though they are, not because the legal risk is greater, though it is, but because the one tool that has always been available to manage the stakes and the risk, the tool of delay, has been specifically and deliberately taken away by the structure of the order itself. Watch what happens in these 48 to 72 hours. Watch what Trump's legal team files with the appeals court. Watch what the emergency pause request argues and how the appeals court responds on that tight timeline. Watch whether compliance or contempt is the final outcome. And watch what the sworn testimony, if Trump ultimately sits in that chair and answers those questions, produces as a legal record that will be available to prosecutors across every active case at the same time. That story is even more significant than everything covered here. The witness chair is waiting. The oath is waiting. The 48 to 72 hour clock is running. And for the first time in 4 decades of legal fights, there is nowhere left for the delay machinery to go. There is no next legal move that pushes the deadline further. There is no appeals court ruling that arrives after the testimony window has closed. There is just the chair, the oath, the questions, and whatever comes out of Trump's mouth next. Permanently recorded, permanently available, permanently part of the legal record that will define the final chapter of his legal story.